Hi guys, so this is now video 3 in the little series of strengths and weaknesses against the defendants. This is obviously relating to the Darren Henson Bye 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 dance. So this video is about defendant Epic Games. Now most people will probably know Epic Games better for Fortnite. They are being sued because they had the emote, the Deadpool and Wolverine emote, which included the Bye 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 dance. This was allegedly licensed from Sony. However, I will say Sony don't hold the license for Deadpool and Wolverine themselves. That had to have come from Marvel and or Disney. So, you know, there is a link back to Marvel, even with Epic Games. And this is kind of how complex these things can get and intertwined. So, I'm going to look at Epic Games and kind of weigh up the potential defenses they may have, and whether the claim against them is strong or any weaknesses. I think I personally rank them as joint second. Joint second, along with Richmond Street Productions, who are the shell company, the corporation owned by Marvel, and they're the LLC that was registered specifically for Deadpool and Wolverine. I don't think they are as strong as the claim against Sony, but they're right up there. So, we start at the beginning, we got the core allegation. There's a quote from the amended complaint. So, SME gave Epic Games a non-exclusive right to use the work in its entirety as an emote in its video game Fortnite for a limited term. Epic Games made such use of the work and profited from the sale of the related emote. Because these things actually cost a lot of money. Like, they cost people who want these kind of emotes, you have to pay quite a bit for them. I think it was £20. I'm pretty sure it was around that if you wanted the full package on the emote. I remember something being on sale for about £20. So this is textbook copyright infringement scenario. If Sony lacked the rights to license the choreography, which at this stage we believe that's the case. Now, Epic's conduct was not incidental or de minimis. It constitutes mass commercial exploitation across every dimension of the exclusive rights bundle. The choreography was reproduced in its entirety into the Fortnite game engine. It was delivered globally to millions of paying users across platforms. It was displayed at scale within the game's live environment. And it was monetized directly through in-game purchases, generating sustained commercial revenue. So why do I think the claim is very strong? I'm relying on 5 independent pillars. Each reinforce Epic's liability. So together they form an exceptionally robust infringement case that is difficult to defend against on the merits. Firstly, the entire work was used. It wasn't just a snippet, a gesture, or parody. The full choreography was reproduced, and this is the strongest possible infringement theory. Commercial, global, and continuous. Fortnite emotes are sold directly, used by millions worldwide, and monetized repeatedly as part of Epic's core revenue model. Invalid license from Sony. If Sony did not own the choreography, its license to Epic was void. A license from a non-owner provides no defense. Epic becomes a direct infringer. And I've done a whole video on this case, which I will link in the description. But then there's the Hanagami precedent. So the Ninth Circuit already ruled that choreography is protectable and Fortnite emotes can infringe. Okay, so we've already had cases for the Carlton dance, for the backpack kid dance, you know, the swish. And I can't remember, there was another dance as well. And I went through it all in graphic detail as to why those dances, they did not hold their cases, and their cases had to be withdrawn, largely because they weren't actually registered, because they were considered too simple. So there was no copyright registration. Henson's work is copyright registered. So therefore this case is already much stronger than Hanagami in every material respect. But the underlying judgment in Hanagami was that, in theory, yes, if the routine is quite complex, especially if there is a copyright registration, but, you know, even if there's not, you can look at, you know, the likeness, then there are, you know, if you satisfy certain criteria, then yes, the Fortnite emotes can, in theory, be infringing. So our starting point here is that, you know, Henson has copyrighted his work, and it is considered complex enough that it is copyrighted. And not only that, the work has been reproduced entirely identical to the original. And then finally, factually bulletproof. So the emote exists on record. Millions have seen it. Epic sold it. No factual ambiguity. No he said, she said. So the overall strength assessment, right? So 100% of the entire work. They used the full choreography, the strongest infringement posture. Now, when I was doing the Richmond Street Productions video, one of the defences that Richmond Street Productions can put forward is, well, we didn't use the whole dance. It was just snippets, you know, in between fight scenes, which is true. Problem is Nick Pauly would have done the entire dance, right? So yes, they edited out certain parts to, you know, and it's supposed to be like a side bit. But the entire dance was done. Nick Pauly didn't just dance the steps that you see on the screen. He danced the entire thing. And then it was discretion of, you know, most likely the director, Sean Levy, what parts of the dance, how much of the dance they used. But the fact is, in theory, they could have used the whole dance. And we do actually have an interview where Sean Levy, you know, has even talked about, with Ryan Reynolds, by the way, talked about, you know, doing a whole video of the full dance as like a, you know, an add-on, like a behind the scenes add-on, you know. So the fact that they have the ability to do it because they have the full dance sequence filmed, I don't think that defense is going to hold up. Now, in Fortnite, the Deadpool and Wolverine emotes used the entire work, the entire dance. Then secondly, the exposure rank. So Epic ranks among the two, well, I put 2, but actually it's third. I ranked them joint second with Richmond Street Productions. So they're amongst the 2 highest risk defendants, and technically the second category includes 2 in the entire action, and that's alongside Sony and Marvel. Ninth Circuit precedent. So the Ninth Circuit ruled against Epic in Hanagami controlling authority in this jurisdiction. So for me, the verdict, the claim against Epic Games is extremely strong. Epic is one of the two defendants in this case with the highest liability exposure and the most limited access to complete defences on the merits. So, like Sony and Richmond Street Productions, Epic Games does actually have some defences it could utilise. They have varying degrees of, well, prospects of success. So, none of them are silver bullets. Each defence must be evaluated both for its potential to eliminate liability and its practical utility in limiting damages exposure. So the following analysis ranks Epic's defences from strongest to weakest. So firstly, we've got license reliance, which I think is stronger. Innocent infringement, work for hire, and then fair use and de minimis. So understanding the ceiling of each defence is critical to calibrating settlement strategy and damages exposure before trial. Okay, so reliance on Sony's license. So Sony represented it owned the choreography. It executed a formal license to Epic. Epic reasonably relied on Sony's representations, and Epic had no reason to suspect Sony lacked rights. That's going to be Epic's argument. Strategic value and limits. So this argument is powerful for reducing damages, shifting blame to Sony, supporting indemnity cross-claims, and arguing innocent infringement or lack of willfulness. However, good faith reliance does not eliminate direct liability. Courts consistently hold that a license from a non-owner is void and provides no defense to the underlying claim. Okay, so innocent infringement. Epic can credibly argue that it believed Sony held valid rights, relied on industry custom and practice in licensing emote content, received no notice of Henson's claim until 2024, and took prompt remedial action once notified. Now, this is a significant damages mitigation tool, as I've said previously. Statutory damages can be reduced dramatically where a defendant had no reason to know its conduct constituted infringement, right? So, innocent infringement can, in theory, reduce statutory damages. And I said this in the Richmond Street Productions. It can reduce per work statutory damages as low as $200 compared to up to $150,000 for willful infringement. So that is a 750 times differential. So if they can make this argument stick and they can make it, they are successful, then they can massively reduce the damages, the statutory damages. What innocent infringement cannot do is remove any liability. So the finding of infringement would stand. Innocent infringement affects the quantum of damages only, not the underlying verdict. Work for hire theory. So Epic's argument could be Epic may contend the choreography was created for NSYNC as part of a promotional video, constituting a contribution to a collective audiovisual work, and therefore it was owned by Sony from inception under a work for hire theory. Okay, why this is going to fail? No written work for hire agreement has been produced. No assignment of rights has been located. Motion picture registrations do not cover underlying choreography. Sony itself could not locate any assignment after 2 years of searching. And I think also what has not been added there, has just kind of come to my mind, I think it's going to be very difficult, especially now Darren Henson has actually registered the work. He owns the copyright of that work. It's in his name. This defense is effectively neutralized unless Sony produces a signed contract. The complaint directly rebuts each element. So it's the same as the other defendants so far. Is if Sony can find this work for hire contract, then everyone is shielded. But if they can't, everyone is liable. That is why for me this is such a fascinating case. It's going to be a proper, cliff edge to it. Okay, so fair use and de minimis use. Both of these, I don't think either apply at all. Fair use. Epic cannot credibly argue fair use. The use was fully commercial, non-transformative, and used the heart of the work. It substituted directly for Henson's own license and market and was monetized globally at scale. All 4 fair use factors weigh against Epic. And then de minimis, I think, is unavailable. Epic used the entire choreography. There is no credible argument that copying 100% of a protected work is de minimis. This defense is foreclosed as a matter of law on the facts. Both of these defenses should be treated as non-viable. Relying on either at trial would likely damage Epic's credibility with the jury on the stronger defenses. This is a non-starter as well. Statute of limitations. Epic may attempt to argue that Henson's claim is partially time-barred. However, this position is difficult to sustain on the facts alleged. So again, statute of limitations is a defense. Generally, it is a defense. But I'm going to explain why it doesn't apply, if that makes sense. So, continuous infringement. The emote was available in Fortnite continuously over, I believe it was over the 2 years. I may not have got that. Different sources I've looked at have said different things, but I think it was for some considerable time. It was certainly over months, but I'm pretty sure it was over close to 2 years. With each sale constituting a fresh act of infringement. Hold on, that was supposed to be multiple months. Okay, that's my bad. Yeah, so it's supposed to be the emote was available in Fortnite continuously over multiple months, with each sale constituting a fresh act of infringement within the limitations window. Yeah, that makes more sense. Right. Discovery rule. Henson alleges he discovered the infringement in 2024. Under the discovery rule, the limitations period runs from the date of actual or constructive knowledge, not the date of first infringement. There is a 3-year time period for Copyright Act limitations, okay? And obviously 2 years is well within that. Global distribution. So there was worldwide distribution, which means the infringing conduct was not a one-time event. Damages accrue across all jurisdictions and all sales periods within the limitations window. So, and Matrix. Liability likelihood, very high. Damages exposure, extremely high. There are millions of global sales. The best defenses for Epic is reliance on Sony's license, innocent infringement, and indemnity from Sony. Weak defenses are fair use, de minimis, work for hire, because we can't find the contract, and statute of limitations, which does not apply. And again, the other way they can use the statute of limitations is, again, the fact, same as Sony. Well, Henson didn't actually say, hey, this is my work for a long time. It kind of went unchallenged, and NSYNC were using it in their live performances. Overall risk, high to catastrophic. Epic is one of the defendants with substantial exposure in this action. So that's where I sit with this. So obviously I've done the first 3 defendants, and they are, for me, the ones with the highest exposure, the strongest liability. So I want to just very briefly touch on this, because again, I've done this in its own dedicated video, which I'll link in the description. But the Hanagami precedent, why it matters here. So I can't say it now. In Hanagami against Epic Games, the Ninth Circuit delivered a landmark ruling that directly governs this case. The court held that choreography is protectable expression, that Fortnite emotes can infringe choreographic works, and that even short sequences may qualify for protection. Epic cannot fall back on its just a dance move argument. Henson's case is stronger. The choreography here is longer, more iconic, and globally recognized. And as I've said several times, if I put out a video of myself doing that dance with no music whatsoever, right, people would know exactly, instantly, what dance I'm doing. Even before Deadpool, people of my kind of generation knew that dance. And they knew which song it had come from. It is globally recognized. The entire routine was used. So unlike Hanagami, Epic allegedly used the complete choreographic work, not a portion or approximation. And then direct commercial profit. Epic sold the emote as a discrete in-game purchase, creating a direct causal link between the infringement and the revenue generated. So, final takeaway, I guess, to summarize. Epic Games faces one of the strongest claims in the entire case: the convergence of full work reproduction, global commercial exploitation, reliance on a void license, and controlling Ninth Circuit precedent creates a damages exposure that is, in the worst case, catastrophic. So again, to recap, the full work was used, entire choreography reproduced, the strongest possible infringement posture available to plaintiffs. Global sales sold to millions across every major platform and territory, maximizing actual and statutory damages exposure. Then we have void license. So, from what we are aware, the position right now is Sony allegedly had no rights to grant. Epic's reliance reduces damages but does not defeat liability. And then we have binding precedent. So the Ninth Circuit ruled against Epic in a directly analogous choreography case. Stare decisis works against Epic here. So what is stare decisis? It is the legal principle of determining points in litigation according to precedent, basically. So it's Latin. It quite literally means stand by things decided. Okay, so it just means there's precedent. Epic's best defenses: license reliance and innocent infringement. They are damages mitigations tools, not liability shields. The litigation team should treat Epic as a defendant for whom settlement value is extremely high. That brings us to the end of Epic Games. So I'm likely to be doing Lance Bass next, because I think I want to keep Nick Pauli until the end, because he is going to be a nice segue back into Marvel and any potential culpability on the part of Ryan Reynolds and Sean Levy in particular. So next one is going to be Lance Bass. You're going to want to tune into that, because I do think that Darren Henson has the potential to add another member of NSYNC, and I will show you why. As always, if you've got any comments or questions, please leave them, and I will respond to them as soon as I can.